This is a live mic check. 1, 2, 3, 4, 5. Now on the air.
Good evening. Welcome to the Kennebunkport Zoning Board of Appeals. It is Monday, March 9th, and we're at the North Street Village Fire Station. We're here for our first meeting in the month of March. I have a few things on the agenda, but first we'll start by taking attendance. Kevin McDonald,
Here.
Mr. Fitzgerald,
Right here.
Mr. Fessenden,
Here.
Karen Schlegel,
Here.
April Defoe,
Here.
and I'm Paul Cadigan, so we're all here full board tonight. Well, no, we still don't have Gordon. There are two sets of minutes to be reviewed. The one's referenced in the, on the agenda, and the other minutes are not. Does everybody have a copy here of the September 24 minutes? Does anybody not have September 24? Okay, have you guys had a chance to look over the September 24 minutes?
Yep.
All right, so since I didn't participate in the meeting, I can run this component of it, but I don't have a vote with regard to accepting or and approving or amending the minutes. Does anybody have any edits with regard to the first page of the minutes?
Well, Amy reviewed them, so I think we do have some update from.
Oh, go ahead.
Yes. So you'll note you should have two sets of minutes in front of you from September 24th. And so there was a request to have Amy Chow take a look at the minutes before the board voted on them. What you have in front of you, the version that Amy looked at, there were some minor changes. As I had a discussion with her about what they were. The primary substance was changing. For instance, there were instances where attorneys were just referred to as Mr. or Ms., and Amy revised that to say attorney. And beyond that, the most substantive change occurred on the, not the last page, but the page before that, where you'll see a bulleted point list.
At the bottom.
Correct. And so the sentence on the original version read, Ms. Chow shared the following notes to be included in the board's formal statement. And Amy's proposed language is, Attorney Chow shared the following notes from the board's deliberation and asked for board input on including the following points in the board's formal findings.
And that's the sum and substance for the most part?
Correct, yes.
Thank
Yep.
you. Other than those, any edits proposed with regard to the first page? Any edits proposed for the second page? Third page? Fourth page? They're long minutes. Any edits proposed on the remainder of the minutes?
I make a motion, we accept the revised version with Amy's edits.
Second.
Wait, with Attorney Chow's edits.
And that's seconded, so we have a motion and a second. All in favor of approving the minutes as presented, raise your hand, say aye.
Right.
All right, and I abstain, so they are so approved. Second set of minutes that we have are those from February 10. So you're out of this one, Jim.
Yep.
As he was not a member, he was not present at the meeting, so anybody have any, these are 2 pages, everybody's had a chance to look them over? Yep. And any proposed edits? None? April, proposed?
No.
Karen,
No.
Wayne, motion?
To accept? Second.
All in favor? Okay, again, it's a vote of 5-0 with 1 abstention, that being Mr. Fitzgerald. Which brings us to the agenda item that I'll read on the record. Item number 2, Ocean Woods Resort Owner LLC, formerly known as Goose Rocks Hotel LLC, Ralph F. Austin Esquire, authorized agent for approval to rescind or amend a 1988 Zoning Board of Appeals decision in order to allow new owner termination of condominium, 71 Dyke Road, assessor's tax map 37, block 5, lots 2 and 2Z in the Goose Rocks zone. So what we'll do tonight is first we'll hear from the appellant or applicant, then we will ask some input from the code office, and then we'll open it up to the public hearing, and then we will close the public hearing and have a discussion of the matter at hand. So, seeing Ralph is not here, I'm sorry, I got to interrupt. I'm sorry, Mr. Fessenden, please.
I am a over 30-year client of one of the partners in Amy's firm, as well as 2 other attorneys in the firm that I use often. So to make that announcement, I believe it would be smart to have a vote.
What are the other attorneys you use frequently?
Harry Center. Recently, yeah. So Keith Jakes and Harry Center.
Okay.
But not Ralph Austin and not,
Not in a long time with Ralph. It's
Okay.
been years. They've been very small.
I don't see any
But no-
conflict
but
in
not-
that.
Is there any reason to think you won't be objective when you hear the matter this evening?
No, I wanted to bring it up because there is money involved, of me giving them money.
I think that money has to come the other way.
Yeah, it's the
actually.
other way that
Hopefully
matters.
it would be less than, see? Anyway, so,
Does anybody want to have a discussion with regard to this before we take a vote? All right, would you like us to vote on whether or not we think you should recuse yourself?
I just wanted to make it clear, and if you believe there should be a vote.
I don't think it warrants a vote.
Well, I don't either. I'm comfortable with it is, but we can do it as a matter of formality. Why don't we do it as a matter of formality? I think does anybody, I'll move that after the disclosure of Wayne Fessenden, that we allow him to continue to hear the matter before us this evening involving, with the party represented by the law firm that he uses. All in, can I have a second?
Second.
All in favor? Okay, we're good. Thank you for that disclosure. Very appropriate. So now, if you would, to the podium. Let us know who you are.
Good evening, I'm Amy McNally. I'm another attorney at Ralph Austin's firm, another partner of his, so I'm standing in it for him this evening. We did submit an application back on February 7th. It's a unique application. I believe it speaks for itself relatively. There was our client, Ocean Woods Resort, who owns the 71 Dyke Road property now. The closing occurred recently on February 28th. We had originally filed while the closing was pending. There is a record on an affidavit from this board on record from 1988, which amended its declaration of condominium, prohibiting certain wet bar units and other structures within the units themselves. The ordinance has since been updated, which allows these kitchenettes, which the declaration prohibited. But furthermore, the motel is no longer serving as a condominium, and our client no longer wants it to be a condominium, so he's seeking to terminate it. And with that, it's difficult, obviously, to do so with the affidavit on record prohibiting any amendments without approval from this board or other town personnel, which is provided in that affidavit, which we did include in the application. So we're looking, and it's again a little bit of a unique procedural request, but what we're looking for is for this board to consider rescinding that affidavit, given the current status of the motel and our client's plans moving forward to operate it as a motel, not to sell separate units, and obviously to be in compliance with the land use ordinance otherwise. So that is the request.
Why don't you just go through a little bit of the procedure with regard to the original application was filed, this appeal was filed by,
Oh,
the original application or appeal before the board was filed by Goose Rocks Hotel LLC, right?
that's correct.
And then your firm represented Goose Rocks Hotel LLC, right?
That's correct.
And at the time, they were interested in the property was by virtue of being the purchaser in a purchase and sale agreement.
That's correct.
All right, take it from there.
And then it was assigned to now the current applicant, which is Ocean, oh gosh, I don't want to get it wrong.
Ocean
The
Woods
Ocean
Resort
Woods, yes,
owner.
exactly. So that was assigned to that. They've since closed. They now have title via the deed, which we submitted to the board on the 28th. So they currently hold title to the parcel and the motel, obviously. It's Ocean Woods Resort owner.
Is there a relationship between Goose Rocks Hotel and Ocean Woods Resort owner? They're both LLCs?
Correct.
No, I'm asking, is there a relationship between them?
They're the same member entities, meaning the same people are in charge.
Okay, so they're different entities, but the reason I'm asking.
Sure.
Is because and I'm sure we can work something out, but there, in the original application, there's a letter of authorization from the applicant for your firm to represent them
Correct.
before the board. And has there been a subsequent filing that gives your firm the authority to represent them before the board this evening?
Yes, we did provide an updated authorization in our communication of February 28th.
Great.
Yes,
February 28th?
that's correct. Ocean Woods, dated February 27th, signed by Mr. Wing.
The reason I'm asking is because I didn't see it, but I must have just missed it.
It's towards the back, I believe, maybe the last page of the submission.
Last page, great.
Sorry about that.
Okay, no, thank you very much, good. Okay, so, anybody, do you have anything? I'd like you to stay so we can ask you
Sure.
questions, but does anybody have any questions that they want to direct towards the applicant? How'd you like us to address you, Attorney McNally? or
Sure,
anything?
that's fine, Amy's fine, either way.
Would you explain to us and also to, I believe, many people watching, the type of ownership, the condominium ownership, how much of the property is condominium ownership?
I believe our client owns the entire parcel, and so he 100% ownership in what was once the condominium units. So by virtue of having over 80%, he would be able to terminate that. And I mean, there's no intention of operating it as a condominium.
Question, were they ever even utilized or used as condos? Because I don't think they were. I thought they were always rented as hotel rooms.
It doesn't strike me as they were. I don't know beyond from when our clients were involved, but my understanding is it's been operated as a motel for some time. But I don't know for certain, beyond recent history.
So I believe from the records that we have that, out of the units that were approved, that only 3 of which I believe were ever actually sold, but then were subsequently bought back.
And maybe owner occupied or family occupied.
Right.
Yeah.
Yeah. Yeah, it's my understanding that Ocean Woods purchased those back at some point. I think when Kathleen purchased the property, she bought the hotel and then also those 3 units that had been conveyed out. So we've only ever had the tax card for the hotel and then, the other 3 units.
So at the present time, you're thinking there are 3 units. And there are how many total units in the?
So based on the paperwork here, it looks like it was approved originally for 35, of which only 3 were sold,
Okay, that's,
but have since all been purchased back.
That doesn't mean that there weren't more than 3, it just means
Right.
only 3 changed hands.
and I'm talking about right now as,
Right. 3 that generated a deed that generated a subsequent tax card.
okay.
So applicant wants us to rescind the condo use.
Not exactly.
Not exactly.
No.
There was a decision by this board in 1988 that amended the declaration, which I believe was dated 1987, and put certain restrictions on the use of them that comply with the ordinance. And so that has kind of limited our client's ability now to rescind the condominium status of the property, because it kind of stalls the declaration in place without approval from the board.
Yeah, so Warner, that was a question I had, sorry for the bouncing back and forth.
Get my steps.
Does that, those restrictions that were applied, you know, when it was a condominium, prevent it from saying, hey, we don't want to be a condominium at this time, and just go back to being a, what are you gonna be? Hotel motel? Correct. Whatever that designation is.
Yeah, so I think it's important to note the distinction between use and ownership. And that, and what we're talking about here is the ownership of the property, and that the intent is to go from this condominium form of ownership back to a singular form, but that it doesn't affect what the use of the property is. Still operates like a hotel, as was proved back when it was originally built.
Yeah, so maybe I'm not asking it right, but.
Well, I do think, so one of the key components, and I pulled the 1991, version of the land use ordinance, because I always like to understand, all right, what were the folks, when they were standing in their shoes, what was the book that they held, in their hands at the time? And so I suspect what had occurred is that there wasn't any distinct language within the hotel motel standards that addressed the kitchenette question. And so based on what I see in terms of the affidavit, that there was a notice of violation that was issued regarding the wet bars. And so as that notice of violation back in the 80s had the opportunity to come in front of the Zoning Board of Appeals, it subsequently resulted in this restriction. I think you saw in the paperwork there was some restriction in terms of outlets, outlets in the wet bars and things of that nature. But then it appears the board went a step further and said that if you're going to make any other amendments to your declaration, you have to come back here. So a couple of things have changed since then. So one, in the current version of the land use ordinance, it has an allowance for kitchens and kitchenettes in hotel rooms, which didn't exist in '91, or when this particular issue was dealt with. And also now condominium declarations follows a separate ordinance process now. Condominium declarations and plans are reviewed by the town attorney and the code enforcement officer. We go through a review and approval process, and those are not subject to a Board of Appeals review. So you've got a little bit of an interesting mix in terms of you've got some past decisions that were done under a different language, different version of the ordinance, but yet we have some controlling language in this document that just on its face brings it back here. I hope that helps clarify.
But as an owner, so I'm an owner and I own a condominium, and I decide I don't want it to be a condominium anymore. I have the right to take that condominium and transfer it to hotel motel and follow those land use provisions, right?
It would have to be more than just a singular owner of a condominium in a large condominium complex. You couldn't do it individually.
Yeah, no.
The whole thing, it would have to be terminated.
Which is what this is at this
What
point in time.
they would like to go.
And I would go back to the distinction and the separation between use and ownership.
Right.
In that, often, when we think condominium, it's residential. We always think of residential condominiums even so much as a use, but they're really not use, Foxbury Woods is a condominium association, is a residential use. Those are duplex, two-family homes that are there. Just happens to have the form of condominium form of ownership. Same case here, you have a hotel use, when it was established, had the opportunity to have had 35 owners.
But
Which
it never
sounds to me
had
like a
those
bit of a
owners.
train wreck,
It never maxed out that ownership.
Correct. Yeah.
And it is in the Goose Rock zone, and it's a non-conforming use now.
Correct, yes. In fact, it was a non-conforming use at the time of, when this document
Yep.
was created.
I didn't look at it, but I presume all the units were owned, but they were just like one entity owned the vast
The
majority of the
developer,
units, right?
yeah.
Werner, hold up, Werner. You're gonna be there a while.
Okay.
And you'll be back too.
Go ahead, Wayne.
So again, for the people at home, if this is approved, of the at least 10 condo, we'll call them developments in the Goose Rock zone, which there appear to be. And as Kevin has pointed out, if someone wanted to come to your office and say, I have bought the 3 units and I want to now make a motel out of it in the Goose Rock zone, what happens?
So I'll go back to the distinction between ownership and use. Okay, so the use of it remains the same. So if we pick any one of the, properties that you're thinking of down at Goose Rocks that are residential, condominium complexes for that matter, the use of it remains the same. I mean, you could have one owner who decides to buy out all of his neighbors and now owns all 10 of these units, and the use is still what it is. The dissolution of a condominium association, I think, has to be taken on a case-by-case basis, depending on, what I'm assuming most condo docs have within their bylaws, a process that's spelled out, which may or may not involve the town at that point. But there's a distinction between use and ownership.
Is your question what could become of a condominium if it ceased to be a
I want to
condominium?
make it clear to the people at home that the Holiday Inn do they have the ability to come in and buy up all of the maritime cottages, which are condos for each individual owner, and make a hotel?
Well,
But
the
hotels
use
not
now
allowed.
is.
That's why
is-
that's why I'm asking Werner, so that
So
other
that would be a
people
change of use,
will
so,
hear that.
Right.
okay.
This is not a simple, this is in the Goose Rock zone, and can somebody put a hotel in there?
They-
Because it's not,
They
to
could
many-
if it was a permitted use and they met all the
Yes.
standards, they could.
which it's not a
But it's not a
permitted use.
permitted use, and they probably won't meet any
Exactly.
standards.
And it's not actually clear, because I think most people wouldn't look up what Ocean Woods is, that it's not all separate condominium rooms. It's a mixed, which I wasn't aware of either till I asked, so that's why I bring it up.
The 3 units that we're talking about here that were condo units and now are reverted back, is there anything to bring them into code compliance and today versus what they were back when they were originally?
Well,
They haven't
they'd
changed.
still be condominium units.
Yeah,
it'd
they're
just be
still-
under
they're still condo
singular
units.
ownership.
I know, but is there anything to bring them into more
So
compliance?
I'm not aware that we have, I'm not aware of there being any, physical zoning or code issue, code-related issues on the property, that would trigger any particular issues in regard to this application.
Wait, I have some questions.
Oh, for Warner?
Yeah,
Sorry.
is that okay?
Sure.
So back when this original affidavit thing was filed, Ocean Woods was running as a motel, hotel, whatever you want to call it, back then, just as it is now. It hasn't changed in the 20 years, 30 years since this affidavit went into effect, making it, or allowing it to be condos, correct?
That's my understanding.
Do you have a problem code-wise with this change?
No.
Do the rooms have wet bars in them now?
So I have not been in all of the rooms there, so I can't stand here and tell you 100% which ones, do or do not have a wet bar.
If we allow this change to go through and let it change from condominiums or do away with the affidavit that was filed back in the 80s, the conditions in there were that there were no kitchenettes. So if that goes away, that means kitchenettes will be allowed according to the ordinance now, because the ordinance today allows them.
Yeah.
Is that correct?
I mean, I can't speak to an application that hasn't been filed with us, but, we do have a section in the ordinance that allows for kitchenettes to be in hotel rooms. I will point out there's very specific language in there, and I think this was, again, I'm speculating on the history of how that language came about.
And there being the affidavit?
Being within the ordinance.
In the ordinance.
Is that, there's specific language in there that talks about, that rooms that have, kitchenettes are not to be used as residences, and that they're not there to be used to establish residency. And I think that was a common, fear of hotel rooms that had cooking facilities that, that folks would move in. They would stay in these hotel rooms long term, without paying their share of property tax. All those types of kind of fears that were held during that time era, which is why I think that language found its way into the ordinance that specified specifically that even though they may have cooking facilities in them, they're not residential dwelling units.
I have a question. Would the addition of kitchenettes, because I'm trying to anticipate why they want to rescind this and what they may want to do for some renovations, it is all on private septic. Would any septic need to be updated to accommodate any of these kitchenettes if
No.
they chose to do that as an upgrade?
No. I mean, septic system design is done based on the number of bedrooms.
Yeah, I
Yep.
just had to ask. All right.
Well, and the other thing was, they said they're willing to keep those restrictions in place.
I have a question about that. I
Right.
think we need Amy up there for that.
Yeah,
The current, if the affidavit is removed, the current land use ordinance does describe non-residential units as a whole. I can't give you the number right offhand, but it's, so that a motel unit cannot be converted to a residence.
Correct.
77E.
Okay, so if the affidavit goes away, it's still there. It isn't as if,
Correct, yeah,
Right,
there's
ordinance.
a specific
But the
performance standard in the hotel motel performance standards.
Right, but the
Yep.
affidavit prohibits cooking, and the
Ah.
new ordinance language would allow it. So that's the
A
difference.
kitchenette, not a full stove, right?
Well, I believe it says kitchen or kitchenette.
Yeah, it does.
I'm sure you'll be up again. Let's hear from Amy for a minute. Amy, I have a question. On the original
Yeah,
submission
that's what I
on the
wanna know.
second page, which is, I think Kevin was bringing up a little while ago, it's the third full paragraph down, says, should this board have concerns about the allowance of kitchenettes in the motel units, then my client is prepared as part of the termination of the condominium to record a deed covenant reestablishing the same restrictions that are in enclosed affidavit. So what are the restrictions in the affidavit that you are willing to turn into a deed restriction?
Well, it looks like, to that end, I mean, number 3, paragraph 3 on that affidavit speaks to that. I mean, I think
This is the affidavit of Mary Huff.
that's correct. I mean, obviously, our, what we would prefer is, I mean, the priority here is rescinding the condominium, terminating the condominium. I mean, I think no stove, hot plate, microwave oven, that sentence, I mean, I think those are now permitted by the ordinance. We would prefer to have them. I mean, I think most every hotel, motel room has a microwave oven, and that's less of a fire hazard. But if the board is concerned about other fixtures that might be more of a fire hazard or something, I'm sure that, again, it's a concession, as we've indicated in the letter, that we're willing to make. However, I think there's been, updates in technology that would make these less concerning to the board, I think, at this time, but.
So, I'm still a little unclear. So, I wasn't sure why the offer was being made, but since it was being made and people seem to have interest in this subject area, do you know the affidavit, if you would stay there?
Sure.
But if you would stay there, Warner, are some of the items in the affidavit, so this is the affidavit of Mary Huff, who was chairperson of this board, back in 1988. There are several, I guess, required conditions. There are 5 conditions that are listed. Are any of these conditions, Warner, you've compared the ordinances, are some of these not just simply allowed? There are a lot of restrictions here. Is it possible for us to identify that which is allowed now and that which would not be allowed?
I think it's all allowed.
So if we're doing a, comparison here, so the current ordinance specifically allows, well, I'll just read you the language of what it says. It says, where a hotel or motel provides kitchens or kitchenettes and guest rooms of less than 1,100 square feet in area, such guest rooms shall not be considered dwelling units for purpose of this ordinance, so long as the guest rooms are occupied exclusively by hotel or motel guests who occupy such guest rooms for no more than 120 days in any calendar year. And so, it speaks pretty generally, in terms of, kitchens or kitchenettes. So, now the affidavit that I'm looking at here, has this decision that speaks specifically about wet bar units not being allowed to contain any outlets or plugs capable of providing electricity for a stove, hot plate, microwave oven, other fixture or device used or usable to heat or cook food or beverages.
Let's stop there. Would
Yeah.
that be allowed today?
Yes,
Okay.
that would be allowed today under this language that would allow for, a kitchen or a kitchenette.
And then number 2 is the condominium documents be amended in a manner proposed by the applicant in accordance with Exhibit A, so we'll skip over that. Number 3,
Yeah, number 3, that no stove, hot plate, microwave oven, or other fixture or device used or usable to heat or cook food or beverages be used or kept in the condominium units other than apartment units 33 and 34 and kitchen dining room lounge unit 35 without the prior written approval of the Kennebunkport Board of Appeals, Kennebunkport Planning Board, and other necessary town officials.
would all of those items be allowed today under today's ordinance?
They would.
Okay, number 4 has to do with amending or changing the prior approval of the board. So those are really the specifics as to the activities within that have to do with facilities,
Yeah.
so to speak.
And in terms of, potential amendments to a condominium plan, that's, most condominium plans have built within allowances for, minor revision, minor revision process.
Right. Okay, so back to Amy. Thank you, Warren. So what I don't get, Amy, I mean, I'm hoping that there'll be a satisfactory result for you this evening. But I didn't follow, when I read that in this letter, the prior part said, it would also allow my clients to install kitchenettes in the units that is now specifically allowed pursuant to 778. And then the next paragraph says, but if you're worried about it, we will do a deed covenant reestablishing the same restrictions that are enclosed in the same affidavit. But were you all saying that you would agree to this limitation that is now a permitted facility?
It's certainly not the preference, it's certainly not our wouldn't be our preference. Our priority is to have the condominium terminated, our preference is to allow kitchenettes consistent with the ordinance today. That's certainly priority number one. We were prepared to entertain a concession in the event the board had serious concerns about doing so. We don't think it's necessary, we think it'd be consistent with the ordinance. It's really, as Warner explained, it's an ownership change where the current declaration of condominium allows for termination with 80% or more of ownership interest. We have that, the same with main law, so that's really the priority. Again, we were willing, just having a conversation about this. If the board did have concerns about certain kitchenettes, then we would have that conversation. I guess that was really the proposal we were trying.
You were queuing up a concession if need be.
If need be, but I don't think it's necessary in this. We haven't heard concerns from the town. Again, it would, whatever was implemented in the future would obviously be in compliance with the ordinance.
Yeah, so can you explain to me, you're going to step away from being a condominium, and you're gonna become
Hotel motel.
hotel motel.
Private.
So I heard some of my board members say, well, that's not allowed in the Goose Rocks,
So,
but I am reading, it is allowed with the site plan review, right, and approval? Am I reading that correctly, or? So if it's not allowed, Warner, how do they become a hotel motel?
Because that's what they are.
Because they already are.
They
They
okay.
have been since
They're grandfathered.
since the early 80s when it was built.
do I even say I had my wedding reception there in 1986? Whoops.
Okay, so that's, say you guys had some pieces that I didn't understand there.
What room
So-
are you in?
We took the whole building.
You didn't have a wet bar, did you?
Okay. So I guess I go back to my original question.
What was the
which-
original question?
Which is, why do we even need to have this conversation? Because they are fully within their rights, based on what you just told me, to rescind being a condominium and go back to the hotel motel
This-
status and follow all of the land use ordinances
Well,
that are part of that, right?
so my answer to that question would be, and then
Because-
Amy can correct me to whatever extent I'm wrong, is that they're obviously, the use of the property, well, whatever it may be, must be conforming to the rules and the regulations and the requirements of our ordinance and our approvals. And some of it's grandfathered, some of it may require new approvals, but it's all gonna still fit in the ordinance. But when the prior owners went for to put in wet bars, which were precluded back in the day in 1988 under the ordinance in effect at that time, they were cited by the code office, and then they appealed that decision to this board. When they appealed that decision to this board made a compromise to an extent that allowed them to have kitchenette, well, allowed them to have wet bars, but really put in some restrictions so that they could not convert them to kitchenettes. But as a part of the approval in 1988, there was the requirement imposed that said that they cannot change the condominium declaration, the governing piece of writing that governs the condominium and calls for its creation,
Yeah.
without the permission of this board.
Right.
So in order for the current owner to terminate the condominium form of ownership, they need this board's approval one way or the other, either by rescinding the prior approval or by us finding a different pathway to come to the same conclusion that allows them to go about terminating their condominium. How you doing that?
So
You're right, Paul.
Well, I mean, the way I was thinking about it, if they're no longer
These
a
restrictions
a
on
condominium, then these restrictions may no longer apply, right?
that's,
That
that is a point
I
of
mean, that's
view.
the way I kind of
That's a point
thought
of
about
view.
it as I went through it. But
That's a valid
I don't know
point
if
of view.
that's valid or not.
I kind of like that.
So the question, as I understood it, was how would the condominium be terminated but for this affidavit? Is that how I'm understanding
The
it?
question is, why are you here?
Sure. The question, that's a great question.
else
No,
are you doing in one
our view is that this affidavit on record inhibits our ability to terminate the condominium. And under Article 6 of the Declaration of Condominium, which isn't in the application but is on record, there is the ability to terminate with 80% or more of the ownership, and that's, like I said, compliant with Maine statute. So absent this affidavit, it would be a relatively straightforward process to terminate. This being on record, clouding the title, is really inhibiting our ability to do that from our view, and kind of, obviously, we want to make sure that we're in line with what the board's asked this entity to do.
So the only reason that the applicant is here this evening is because the applicant desires to terminate the condominium form of ownership, but this affidavit, not the stuff about the kitchenettes, but this affidavit precludes the owner from doing it unilaterally.
Okay.
Because it's a change in the declaration, and this board needs to, in essence, allow for that.
Get rid of it.
And then, so is that?
That's exactly correct.
Thank
The affidavit says we need to do that, so.
So I have a question. I don't know if you can answer this. So is it the applicant's intent to renovate the rooms and add kitchenettes or kitchens to all of them? And would there be any type of a timeshare or a quarter share sale of any of these units?
I think eliminating the condominium, there's no intention of selling the property. That's not on the table. As far as renovation, I can't speak to that. I mean, that would obviously be a permitting process through the code enforcement in any event. But I can't speak to any immediate plans about that.
But the intent is to run it as a hotel?
That's correct.
Rent rooms, rent
That's
nightly
correct.
rooms? Okay. Still have the restaurant and the lounge?
Is my understanding.
And we're okay on parking capacity and all that? Well, we're not here to rule on that. Okay, so forget, doesn't matter.
That's not our, that's
Yeah.
not our jurisdiction.
Yeah,
Not in our
forget that,
purview.
yep.
Careful what you say.
So,
Yeah.
Amy, you've asked that this be rescinded, or, I can't remember the other word. Rescind or amend the 1988 zoning board decision. So couldn't we do a third thing, which is, I don't, it was a valid decision at the time. And so if there's a way to not rescind a valid decision at the time, that'd be my preferred avenue. And it says in the affidavit that this is number 4 of Mary Huff's affidavit, that the portions of the condominium declaration set forth in Exhibit A attached hereto may not be amended or changed without the prior approval of the Kennebunkport Board of Appeals, the Kennebunk Planning Board, or other necessary town officials. So if the Kennebunkport Board of Appeals approved the proposed change to terminate the declaration, doesn't that serve your purpose?
I think it does. My only concern about that, I certainly appreciate that. The only concern about that is Exhibit A doesn't speak to Article 16, which talks about termination, so that'd be my only, other than that, I think,
Slow down for a minute. Article 16 of,
of the condominium declaration is what speaks to termination. But I think if the board makes a decision that it approves the termination of the condominium, that's probably
oh,
sufficient.
no, I'm not saying that the board would terminate the condominium. I'm saying that the board would authorize the owner to terminate the
terminate, correct.
condominium. And then you'd satisfy the section
Right.
16 requirements of the declaration on your own, however, we don't know
Sure.
what they are.
Sure.
However you need to do them. Wouldn't that accomplish the same thing without us having to reverse a prior decision?
But I think they want to
It would
get,
limit their kitchen use.
No, well, no,
I think they want to get this off the books
Yeah,
so that they'll have a clean title and not have this affidavit hanging out
but
there.
if they have a decision from, well, we can discuss this.
right, yeah, right, I guess I don't know where that leaves the rest of the affidavit,
What if this board decided that those items in that affidavit that are no longer prohibited by the ordinance are indeed no longer prohibited?
that would probably take care of
Wouldn't that
that.
accomplish everything you need to accomplish? Those two things?
Correct, saying, right,
If this board said that it agreed to the proposed change and gave the owner the authority to terminate the condominium, as that would be the change to the condominium that's requested, and that this board said that any item that's in this affidavit that is now permitted under the land use ordinance would be so permitted, wouldn't that give you what you need? Wouldn't that give you everything you needed?
I think so. I'm thinking of worst case scenarios, but
Keep
I think
thinking,
so.
keep thinking about it, all right.
So then in essence, are you suggesting that we're?
Well, we'll talk about it. but
Okay.
I mean, I think that's an amendment to, I mean, that would be an amendment, so,
Well,
right,
the
yeah,
question, it says an amendment
or
or
rescind,
change
right,
without prior approval. So you're
Right.
proposing the change, and the proposed change is termination. So
Correct,
if the
yeah.
board approved the change,
Mhm.
then you'd get what you want. And we wouldn't have to flip a decision that was probably well-founded and established in 1988.
sure.
So Paul, my only other kind of view of that is if we did rescind it, we'd be rescinding it based on the fact that they're moving in the direction of no longer being a condominium, but being a motel, hotel, and that we weren't really overturning the decision that was made at the time, but we're rescinding because
We're not,
in their new form, we would be rescinding because in the new form, it doesn't that affidavit doesn't really apply anymore.
some might be of the opinion, like you were expressing, that if they were allowed to terminate, then the affidavit wouldn't govern. But I think from a title perspective, they have the heebie-jeebies about everybody having to draw that conclusion. They'd rather have it spelled out in bright lights.
Well, that's why I was thinking of, if you rescind it from a title perspective, I gotta think that's cleaner than if you have some other rescinded, and then it's clean, I would think, from a title standpoint, right?
That's what they would like the whole enchilada rescinded, I think.
Yeah.
Because if we terminate the condo,
No, we're not terminating the
Yeah.
contract.
okay, right,
We
right.
would be authorizing we would be authorizing the owner to terminate the condo if the owner so chose.
Yeah,
We can't of ourselves
Right.
terminate a condominium.
and then the affidavit almost is non-effective because it all discusses condo. And now,
But we could look at that, we could discuss that as to see a way to, I'm not at all of, I'm speaking, I'm getting ahead of myself, but I don't have a problem with your, what you're proposing, but I'm not easily inclined to flip a decision, if we don't have to flip a decision.
oh, we could add a restriction to it.
Well, we can do something, we can discuss. But that's the only questions I have for the moment. Anybody else, questions for,
And as Werner was very clear, us at number 4, allowing, or when it's brought before us to amend or to change, they're asking for a change of ownership, not a change of use.
form of ownership?
Ownership in that one paragraph. The other parts would be a change of use, not dramatic, but it seems to me it's 2 parts.
Let's discuss when we get to that. Thank you. if there's no more immediate questions, I'd like to open it up to public hearing. And we'll have a bit to discuss, yes. So I'd like to open the public hearing now. Is there anybody that would like to, okay, come on up, go to the microphone if you would, let us know who you are, and then say your piece.
My name's Wesley Phillips. I'm a butter of the property. And the motel, condos, whatever they're called, they've been good neighbors. You know, they've been there for quite a few years. But my question I have probably goes more to you, Ronna. Is there a grand plan that you're aware of besides switching over from condos to motel, hotel? I've been watching the surveyors out there for the last couple of months, and I've walked out there and I've seen little red marks on the ground and everything else. And just being a Mainer, I'm suspicious. You know, is there a plan to get house lots in there? If it's a inn versus a condo, does that restrict the house lots? It looks to me like they're putting a roadway up where the septic system is. Kathleen, who was the current owner, came to me about using my driveway to access a couple lots down there. And so did Neil Laney, who also wanted to access the driveway. But I have resisted that because I don't want the liability and traffic and whatever roadblocks the planning board will throw up at me. So, are you aware of anything like that going on?
So what I can tell you is that over the course of numerous years, you know, that there is upland in the back of the property,
Yeah.
you know,
Yeah.
that's separated by a wetland area. I've discussed with Kathleen a number of times that, you know, she had a desire to build a house out back some time ago. You know, I presented to her the different challenges that she would, you know, potentially go through, you know, in order to accomplish that. So I know that she did some level of due diligence. I know that she had conversations, you know, with you and with the neighbors, but none of that came to fruition. You know, I suspect just, you know, there was too many roadblocks. So I'm not aware, you know, I have not received any plans for any redevelopment of the property at this point.
Because one of the big issues she had was because it's an inn and their water supply, she couldn't have anything, house lot with a septic tank or anything within so many feet of that water supply.
Correct, yep.
And,
Yep, yeah, there's a significant well, there's, you know, a well that has a significant, I think a 300 gallon per day or per hour charge to it. I mean, it's pretty, you know, it's quite a well, that's actually listed on a database as a community water source. And so as such, it has a lot of, you know, it has a much higher, degree of setback, to it specifically, so.
and it looks to me like, looking at some of the surveying that's been done, I mean, if people who are purchasing this property, they have the wherewithal, they could just bring the sewer line up to that hotel. I think the water line is by it now.
It's a seasonal.
That's okay, you're right,
Yeah.
yes. Do all that, and they could just put the road up there and put houses. And I'm not, you know, if they meet the requirements, I don't care. But I was just curious if there's
Yeah.
any kind of a grand plan.
Not that I'm aware of. I mean, I'm sure everybody has grand plans for their property at some point. But there's none that have been discussed with me at this point with this current owner.
But this application that she's making is, no, like I said, they've been good neighbors and people who can buy it. They've done pretty good work for all the places I've seen in town. But anyways, that's the only thing concern I had.
Thanks, Mr. Phillips. Thank you. Anybody else? Okay, hearing nobody else, then I'll close the public hearing at this time. And we can start our discussion of the matter. You get the point that I was making on this? My preference is not to overturn a decision that was rendered in 1988 that was probably well-founded at the time. I kind of like to not turn a decision over, it's unnecessary. And there's a path here because on the, putting the affidavit aside for a minute, but the affidavit, not putting the whole of the affidavit aside, but the affidavit does say that if the owner wishes to amend or change, I'd like to get to that language. That the portions of the condominium declaration set forth in Exhibit A, so first of all, it's narrowing it down to only some sections in the declaration, very minor amount of sections in the declaration. Here too may not be amended or changed without the prior approval of the Kennebunkport Board of Appeals. So the owner has the desire to terminate the condominium form of ownership. And that's not really an amendment to these particular sections of the declaration. It's a change of these sections of the declaration, which would be to terminate. And I don't personally have an issue with that at all. Though I would prefer, my view, just my view, is not to overturn the prior decision, but to try to work within the confines of the prior decision to grant the relief that was requested, because I don't see anything improper with the grant. I think they're entitled to that grant of relief. And the only reason that the matter's before us is because of this decision in '88. Otherwise, we wouldn't have jurisdiction over this to begin with.
Right.
So, just before we move into like the kitchenette related items, what do you think about that, folks?
Removing, maybe, or taking away the condominium status,
Allowing
them to make
change
that
the
removal.
declaration
So
by terminating.
that then makes the property more conforming?
No, it doesn't really have an impact on it at all. No.
Because it's got two uses, condominium and hotel.
No.
No. Condominium isn't a
Okay,
use.
that's right.
Condominium is just a
Yep.
form
Yep,
of ownership.
ownership.
You know, and
Yep.
mostly down at the beach where Wayne was pointing out,
Yep,
I've developed, I've
Yep.
created condominiums down at the beach, and a lot of the times, it's just so that you've got a property and you've got two residential dwellings on it, but you can't cut the property in half and sell one to A and one to B because the land doesn't support it. So you have to use a condominium form of ownership in order to allow the severance of the ownership of the different units, but it's
Yep.
still a whole. It's that legal fiction we call condominiums. But at the same time, you can terminate it and it's all one again. But it doesn't really have an impact on, they're gonna have to conform, whatever use they wanna have for the property
Right.
has to conform, whether it's grandfathered or it's something new that's being introduced, or if they wanna develop it further, Mr. Phillips, they've gotta get the appropriate approvals from the appropriate boards or the code officer. They'll have to go through all the normal channels. None of that stuff's before us.
Right.
The only thing before us is, do we blow up the decision from 1988, or can we work with the decision in 1988 to render a decision? I'm maybe some of you are opposed to it. I'm not opposed to it. But I think there's a path there without overturning what our predecessors did. That's just my view. What's your view, Jim?
Can it?
can
Take it out.
Can it?
Terminate the prior decision?
Terminate the prior decision. It goes on record. And,
Well, then we have two different
With the-
points of
with
view
the-
there.
yeah,
We have two different points of view.
Oh, I see.
it's, because it gets muddy in section 4 when you talk about, no amendments or changes without prior approval, Board of Appeals,
So we give them one approval and they go terminate. Then it's,
you wanted my opinion.
I did. Well, now I don't. No, I didn't. I was just kidding. Kevin, your thoughts?
Well, I kind of gave them to you before. My view was if, it's ownership, right? Condominium, right? You call that ownership? If it's no longer a condominium, if they eliminate that, in my mind, this doesn't really apply anymore, right? So,
the restrictions in the affidavit.
right, shouldn't really apply, but
Well, we could
I
lift,
also understand that, you know,
but the
from a legal
yeah.
standpoint, I see everybody make faces and they, you know, to make it cleaner, it sounds like, you have to make it very prescriptive
Well, what if we
that it's understood.
what if we voted to lift the restrictions?
Yeah, if you lifted the restrictions, I think that's pretty straightforward,
And
right?
then that
Without
could be something
rescinding.
that would be a matter of record and that would satisfy, we could ask Amy after we finish discussing, but I think that that would ultimately satisfy what the current owner is.
So you're creating a positive instead of a negative. You're being nice to the affidavit. I agree with what you've said about.
I'm trying not to
It's very
over-
well done, it was very well thought of, and what were they thinking at the time? We don't know, we weren't there, we can guess.
Yeah, but based on what we heard from Warner from the ordinance, what they did was render a decision that was in conformity with the ordinance.
At that time.
At that
right.
time.
So times have changed, the ordinance has changed, and we actually have a vehicle whereby we can leave this relatively undisturbed, but we can give the applicant everything that the applicant wants. I guess I'm just,
I can live with that.
I'm just not inclined to rescind a decision
decision,
if
right.
I don't have to. There'll be times when we
can
would
amend
need
it, We
to,
can change it, we can lift it without rescinding it.
as long as it, I mean, I'd like to accommodate the applicant, but I don't know if we have to. I'm sure there's a way we could accommodate without, we're giving them everything that they need and everything that they want, not handicapping them at all, but not telling the board in 1988, we're just gonna blow it up. That's just my personal preference. Yes.
Are you discussing outside that one paragraph now?
Not yet, I'm still,
Okay, we'll stay within
does
that,
anybody, Jim has expressed reservations about that approach, though he's softening up
Yeah.
as we speak.
Yeah. He's tired.
He's softening up. We just
No,
wear him
I
out.
just,
No.
Yeah.
April, haven't heard from you?
I'm inclined to go either way. I don't care. Doesn't matter to me whether we rescind it or whether we amend it so that it stays in place. To me, it doesn't really matter, because first of all, other than the 3 units, I mean, they never really operated it, used that condominium form of ownership. It's always been a motel, hotel, motel. The restrictions about the kitchenettes and wet bars and so forth have been changed, and it's allowed today. So I mean, whatever was allowed or not allowed back then is allowed today. So to me, it doesn't matter which way we go. I think that we can get rid of, I mean, all of it is really, doesn't apply anymore. So I know you want to keep it there.
No, I don't want to keep it there, I just hate to overturn a board's decision, that's
From a
all.
procedural standpoint of
From
overturning
a
the board decision.
procedural standpoint, I
Yeah.
prefer not to overturn a board's decision. It's just me.
And Paul
Because
is,
boards don't usually overturn other boards'
Paul is
decisions.
Well, but they gave
lifting
us
really
the-
different than
They
rescinding.
gave us the ability to do it. I know, technically, we're gonna give
Yeah.
them,
I mean, is
we're
a
gonna
lift
get rid of
different
it
than a
all.
rescind? I don't know.
Well, it's.
A lift is a change, it's not a
The,
rescind.
Yeah.
the components of the affidavit that are problematic are those that prohibit particular, like, I've been using the term facilities, that are now allowed, and we went through the restrictions are really in paragraphs 1 and 3.
Yep.
And Warner has stated, the code office has confirmed, that that all of those items in there that were restricted are presently allowed under today's ordinance.
Are allowed, yes.
Correct? Is there anything?
Yes, correct.
Okay, so if everything there is allowed, we can lift the restrictions that are, because, we won't say that are, I wouldn't say lift the restrictions that are now allowed, I'd say lift these restrictions because they are now allowed. It does the same thing as, rescinding it, rescinding the decision, overturning the decision. I don't want to overturn a decision.
And from a title standpoint, that's a clean path?
It could be written cleanly. I think we're capable.
Could the board issue a new decision that has the effect of superseding the old decision?
That's what we're doing.
That's what we're talking
Right.
about, yeah.
Just not have any rescinding language in it.
Yeah, man, I think we can accomplish all of this.
The final outcome will still allow them to do what they want with their kitchens, we're just not overturning a 1988.
Well, I want to make sure their title's clean too, so that they
Right.
don't
Isn't that
have
the
a,
bigger issue?
they don't have a speed
I think
bump
that's the
with it.
bigger issue, isn't it?
The title?
Yeah,
I think that's the only reason they're here. 'Cause it was found in the title records when they were going to buy
Yeah.
the property, and somebody actually paid attention to reading all of the entries at the registry.
So if we amend it, not only is this going to stay on the title, the original affidavit, but the new amendment will go along with the title as well. So now there'll be two documents going
It's
along
the
with the
same as
title.
if you have a mortgage on your property, and then you pay the mortgage off, and
With
then
a
there's a
discharge.
discharge. The
It'll
mortgage
change.
is still recorded, but the discharge supersedes the mortgage itself. Or
So
if you
our
have
decision
a
will-
deed restriction, and then those members of the association vote to allow you to do something contrary to what the restriction initially was. That's, the original restriction is still effective, but the secondary decision is there and it supersedes. That's just the story of title.
Okay, I mean, if.
And I
if
guess
you-
as a
It
side note,
doesn't matter to me, so if it matters to you, then we can do it your way.
title must not have been all that clouded, because they
Doesn't
went ahead
matter.
and purchased it anyway.
Yeah, well, they're confident in their abilities.
They went ahead and made the purchase, so this was just a little blip, not a,
But Joe Ralph was okay with
Amy, can you come up just for a minute? I want to make sure what I'm talking about is, if the board
I know. 'cause they're up to-
votes to allow the owner to change the declaration by terminating it, you're fine with that element, right?
Yes.
And then if the board states that the restrictions imposed by the affidavit by this person at this date recorded at that book and page are now allowed under the ordinance, paragraphs 1 and 3, and therefore those restrictions are lifted, doesn't that get you where you need to go?
I think it does, so long as you mentioned, that it references affidavit, change in circumstances, change in ordinance, and here's how we came here, and this is the conclusion of the board. I think that gets us where we want to be. You skipped over paragraph 2, and that mentions the amended documents, which again, by virtue of the board approving or authorizing the owner to terminate, I think that
Covers that, doesn't it?
covers that.
I want to make sure that you end up with a clean title, but
Right. And then, obviously, I would just want to clarify that any other change in the property wouldn't need to come in front of the board again,
Right.
unless it was some, obviously, permitting process or other site plan review or anything else that was required under the ordinance.
Right, but doesn't
But
it
that
say
would be
that the
planning
only
board.
changes have to do with the declaration?
Yeah, I think so. It seemed, I mean, I think so. I guess I would prefer if that's clarified, but I understand that,
That's what I'm reading.
yeah.
And it's just a matter of a number of, it's just a minor element of the declaration that's so restricted anyway.
Right, and if it's terminated, then it's likely moved.
Thanks.
I think that's where it gets me.
Am I muddling this up for you guys?
Yes.
No, no, you're not
Well, that's
muddling at
good,
all.
see, there's two ends.
Am I muddling it up for you?
The sixth side
Jim?
says yes.
Well, you can vote against what I'm thinking about, that's,
No, I'm giving you my opinion.
yeah. You want to discuss this any further?
Nope.
No?
The solution is
Can I
there
just ask one
somewhere.
more question of
Please.
Amy? Sorry. by us allowing you to make the condo change and possibly lifting the kitchen at 1988 restrictions, that is only, and maybe Werner, you might need to chime in, that is now only going to allow you to do kitchens in each hotel unit.
Is my understanding of the wording of the ordinance correct?
And
Provided
that's-
this.
you're not looking to do any expansion, because if you do any expansion, that's a whole nother thing, not in front of us, but a whole nother board.
A permitting process, right, correct.
So your intent of coming to us is maybe to remove, change the condo ownership, remove the kitchenette, so so the new owners will be able to put kitchens in every unit?
The priority was to terminate the condominium, but then also the restrictions are now inconsistent with the current ordinance, so we figured that would also be lifted at the same time.
We just know there's probably gonna be some renovation going on, so we'd just like to,
Doesn't matter, it's not under our.
That's not us,
That's
it
right.
just
Let's
doesn't, it's
just
not,
discuss what we're doing today.
Yep,
Thank you.
yep,
it's none of our business.
all right.
Hey, so Paul, my last comment, I think it's cleaner to just do the rescind. But if you have a different path that
Well, I'll
works
make a
out-
motion, and then you can all vote it down, and that's good with me, and then, another motion can come to rescind,
Okay.
and it can go that way. So I'll make a motion. Oh, well, are we done discussing, or do you,
I think
anything
so.
else?
I think we're done.
Oh, you killed me.
Wait, Wayne's not done.
Wayne's not done?
Wayne's,
Um,
Wayne's chewing on something.
Before you make the motion,
Yes,
if a suggestion for the motion.
yes.
If the motion references in some, I'm going to use the word positive again. The board in 1988 did a heck of a job. It's very clear. It isn't muddled, it doesn't, it says what it says, it's fairly exact. And by referencing it and leaving it there somehow, which allows 5 years from now, this board or the planning board can go back to it. Is that, yes, it's a little muddled, but it doesn't, and what I'm getting at is, so Amy comes for this board or another board in 5 years and said, no, the zoning board of appeals said, no, get rid of that. You need to stay with what you decided in 2020.
I didn't follow.
Okay.
Me either.
Me neither.
You are, this is the reference. We are voting, as it says, we are following what the zoning board of appeals said to do in 88.
Yeah,
If someone came before them, and they, before us.
we're
and
just
they-
making
and they
a
did.
decision consistent
Right.
with this.
If we make a motion to eliminate, or to say that's no longer valid, the whole
To
affidavit.
rescind the
It's-
decision.
But, and that the whole affidavit is no longer
Valid.
applicable, then a future board can't go,
Yes, they can.
wouldn't go back to it
Sure they would.
and say, because it doesn't apply. Our motion today would apply, correct? Yes, it's
If
a
I
little-
understand you right, I think yes, but I think it would be the net result of a motion.
Okay, so this would be used as a reference for today's motion. I know that sounds,
Oh, I'd be referring to this specifically.
yeah, yeah. So I'm having a trouble with, I actually see that there's two parts to it. There's use and there's ownership.
I agree. I intended on addressing both.
Okay.
Oh, if that's what your question was.
Well, it was bigger than that, but that's all right.
Well,
Let's see with a motion.
all right, let me try motion. So I would move that the board, consistent with this affidavit, well, strike that. I would move that the board allow the applicant to change The condominium declaration sections are governed by this prior decision, and that change may include a termination of the condominium. And that the restrictions in the affidavit, and I should specify of Mary Huff, chairperson of the Kennebunkport Board of Appeals from 1988, recorded at the York County Registry of Deeds in Book 4960224, page 224, that the restrictions imposed in that affidavit that are articulated in paragraphs 1 and 3 are restrictions on items that are now allowed under the land use ordinance, and therefore they be lifted.
Is that a motion?
Yeah. But if it's not seconded, it won't go very
That's what I was
far.
gonna say.
I'm just reviewing what we just said, but I'm going to second that. I
Can
think
we have
that
some
covers.
discussion on it first,
Yep,
before we go
After the second
after the second?
discussion?
go ahead.
Do we have a second? Yeah.
I did.
Yeah.
So, is this gonna get recorded in the York County Registry of Deeds?
If they want to, they can record it.
Because if it isn't, then
Confident they'll record it at the registry of deeds.
you're confident?
I'm very
But should we
confident.
make it as part of the motion? Because if they don't, then if you ever do title work again on this property, you're gonna find the affidavit, but not our changes.
While I'm confident that the applicant will record the decision, why don't you make a motion to amend the decision that it be such that it shall be recorded in the York County Registry of Deeds?
Our findings of fact.
Our decision.
I'll amend the motion to include that these findings of fact
I'll
be
second.
recorded in the York County Registry of Deeds.
Second,
second.
second the amendment.
Okay. Done with discussion? Okay, all.
Can
in-
we hear that one more time? I mean,
Yeah, can we?
I don't know that I was able to get all of that as you went.
Okay.
Fortunately, we have a great secretary appointed over here.
I actually got it.
All right, my scribbles. Paul W. Cadigan, PWC, made a motion to allow applicant to change the condominium declaration section as governed by prior decision to change the condominium, and that the restriction and affidavit from Mary Huff, 1988, book page reference, restrictions, what's, I can't remember, imposed
in
in paragraphs
1 and
1
3.
and 3 are items now allowed in current land use ordinance, and that they be lifted. And then April made the motion to amend that to include that the ZBA findings of facts be recorded in the York County Registry of Deeds.
Yeah, the only thing that I also said was that they be allowed to change the declaration by terminating it.
The condo.
Okay,
By terminating the condominium. Okay, Jim? Oh,
And 1 and 3 covers everything? I was trying to
I
get back
think
to
so.
the,
Change of condominium or
I'm not against it.
just because this restriction here says that can't be amended or changed without prior approval.
This is the approval. That's what we're
But you're
doing.
making it very, very specific.
Right, we're granting them approval to change the the condominium by terminating it.
and referencing the paragraph 1 and 3 are now in the current land use allowed.
Correct, according to the code office.
Yep.
Okay,
And- Hey, Paul, just, so, number 2 references that Exhibit A. Do we need to include that to make sure all of that's captured so that everything, not,
number 2,
says the
That's the
con,
condominium
That's a
documents
condominium
declaration.
be amended in the,
declaration.
well, that's,
We're gonna be,
that's been done. Now we're giving them the ability to terminate the condominium.
we're allowing them to terminate it, and then they do the termination.
That's what they did
Okay,
before.
okay.
with Terminating, allowing them to
I
terminate.
just want to make sure we're not missing
Right,
something
I don't,
when
yeah,
we're
no, it's a
going
good
through and
point,
doing this.
Kevin, it's a good point. I think we've got it covered. Okay, so anyway, that's the motion.
Want to allow the owner to-
Go ahead.
So I just have a question as I'm following you all, because the affidavit really is, is a document that was created by virtue of the findings. So the findings, so process-wise, you had a board hearing, right?
Yep.
So that created a set of findings, and then within the findings declared that the affidavit would be created. Okay? And so you're now generating a new set of findings that addresses the affidavit. And I guess procedurally, my question is, should it be addressing the previous findings, not the affidavit? Findings being the operable document. And the affidavit is just stating, here's what we decided.
That's an interesting point.
And we didn't have that to review.
It was in the application.
Yeah.
Oh,
Right,
it
as
is.
a supplement,
Yeah. Okay.
part of the application.
Sorry, I don't mean to drag it out.
No, no, it's a good point.
Yes, you do.
But I think that addresses the chair's concern about not simply rescinding it.
Right. The affidavit is a statement that says, here's what we did.
Right.
So if I began that motion by saying that pursuant to the findings of fact of the zoning board dated January 12, 1989, and the affidavit of Mary Huff, recorded in the York County Registry of Deeds and book bank, page blank, that this board approves the proposed change of the applicant to change the declaration so that it may be terminated. That address that one?
Correct.
I move that we amend the beginning of the decision, the beginning of the motion to include that language.
Oh, geez, I missed that.
Did you?
I did, because I was trying to dig the original findings. I missed it. You're gonna have to repeat it. Jeez, cat again. Well, did you just make reference to changing the findings, the prior?
But that pursuant to this board's findings of January 12, 1989,
Okay,
and the affidavit of Board Chairman Mary Huff, recorded in the York County Registry of Deeds
got
in
that, got
book.
that. Yep.
You got the book in the page, and then the rest of it would stay the same.
Because that was just a numbered condition of the findings.
Yeah, does that work for you?
That the affidavit be recorded. The other piece, I know we were speaking specifically about, the numbers in the affidavit. And so, so number 1 and number 3 dealt with the physical component pieces, right? The wet bar, pieces.
Yes.
My concern is that, and I guess you addressed the other numbers not mentioned. So 2, documents be amended in the manner proposed.
That was already
I guess
done, though.
That's void. And then number 4, you still had that kind of hanging out, that the condo docs not be amended.
That's what we're voting on, to
Right.
allow
We're
them to
allowing
be
them to amend.
I
changed.
just want to be clear, because you're only mentioning the two numbered ones.
That they're now currently allowed in the current land use.
Oh, do you want me to make the reference to number 4?
Yes, please.
That's what he's asking for.
In the term, okay,
Yeah.
allowing the
In the
termination,
affidavit.
okay. By terminating the condo docks
Thanks, Warner.
as,
And those numbers in the affidavits are exactly the same as in the decision
decision.
part.
The
of-
book and the page?
no, the
No.
1 through 4, the 1 through 5.
Are the exact same in the decision part of the findings of fact. So we could refer to the findings
they
of fact
are.
instead of the affidavit if you wanted
could
to.
refer to
They are
both.
the same.
Both.
Refer to
okay.
both. The affidavit, the decision and the affidavit. Ooh, good
Well, you're
patching
good
together
sometimes,
nicely,
huh?
very nicely.
As an affidavit. Okay,
You good? Yeah.
I got it.
Okay. So, with regard to the motion as made, seconded, amended, seconded, modified, and seconded? All in favor?
I'll go along with
I'm okay with it.
And
We have
opposed,
everybody?
none? That's everybody.
Okay.
Unanimous. Thank you, Amy.
Thank you.
Welcome. So that ends the hearing of the Goose Rocks Hotel LLC aspect. So now I'd ask the board to take a look at what was circulated at the beginning of the evening, which is an email, I'm sorry, it's a letter that was provided by email from Attorney Laurie, dated March 5, 2020. So, by means of review, Mr. Laurie, on behalf of Randy Slager, filed an appeal with this board. That appeal was dated December 27, 2019, and requested that the remand to the CEO for certification required under 11.5.c of the Land Use Ordinance, and/or the continued suspension or prohibition on use of patio until issuance of certificate of occupancy. And at the beginning of the, on the reason of appeal, on the first page, it said lifting of suspension of permit in violation of 11.5.c. And then if I paraphrased in the body of the appeal, which we all got, we all gave some element of review to at some time. The applicant, or the appellant, had a problem with the format that Warner used when he lifted the suspension that had been imposed on the project of Lori Bell on the land that she owns that abuts the land of Mr. Slager. And so after this appeal was filed, the code officer said that his intention was to revise how he issued his decision with regard to the suspension and the lifting of it. And since that date, we need to schedule a hearing within 35 days of when it's been filed. But there is a provision in the ordinance that says that if the parties agree to an extension of that period of time, then it can be had. And the parties to this, which I would see as the appellant, Mr. Slager and his attorneys, and the code office, which is the party that was, the decision was appealed of, agreed to allow for the continuance beyond the 35 days for hearing, and primarily to accommodate Warner reissuing his, or casting differently his lifting of the suspension of the permit that benefits the Bell property. So initially Warner issued one writing, which was not his final, and then subsequently, I think it was a week ago, last Friday, Warner did issue his decision, which I would consider to be a rather detailed document, in which he did indeed lift the suspension of the permit, and his issuance of his decision, Warner purports that it conforms to the provisions of 11.5C. So Warner did as he said he would, which was to recast his decision. So after he did that, I emailed Mr. Laurie, who is the attorney for Mr. Slager, who filed the appeal, to say, we did extend the period of time. It was extended by agreement of the parties. The purpose of the extension really was to provide Warner with an opportunity to conduct further review and to recast his decision. And Warner has now done that. And so I'm asking you, as the attorney for the applicant, you can have one of two choices, either to withdraw your appeal at this time, because you feel like it's moot, or you can ask for it to be scheduled for hearing. That's your decision. I'd just like to hear from you shortly. And I did say that in the email that, in my opinion, and it was just my opinion, not the opinion of the boards, that the appeal that was filed was really as to more to the form of the decision rendered by Warner, and not so much as to the substance, because 11.5C pertains to the form, the process, the procedure. So the letter that I got back is what was circulated to everybody here, and Attorney Laurie, well, you've all had the opportunity to read the letter? April?
I have briefly, but
Well, Attorney Laurie says that, well, I'll read the letter, all right? Would that make it easier if we just put the letter of record for the moment?
it's up to you. Or you could summarize it.
Roger, I don't think we need to read the letter, but he makes a request in the letter, and that's why I've brought this up before you. So I let him know I thought that the pending appeal had to do with something that Warner did some time ago. And he has recently, do you have the date of your decision, Warner? That Friday, a week ago Friday, was
I
the
believe that was the 28th.
28th of February?
28th of February.
So, when Attorney Laurie wrote back, he said here, I'll read you the last paragraph. I agree that the pending appeal does not lend itself to addressing the merits of the CEO's amended decision. I paused there because the CEO's amended decision, filed on February 28th, was filed 2 months after the appeal was filed. Oh, I had a difficult conceptual time thinking that that appeal could be of something that hadn't occurred until 2 months later. That's what I was expressing. And so Attorney Lowry goes on to say that I asked, therefore, whether the Bell Scannell would object and whether the board would entertain a timely amendment to the pending appeal to allow the board to address the merits of his, being Warner's, amended decision, and to exhaust all administrative remedies to the CEO's acts and omissions in this matter. I interpret that to say that what he would like to do at this time is to amend the appeal that was filed on December 27th, or it's at least dated December 27th, 2019, to allow for that appeal to change to an objection to the decision that Warner rendered formally 2 months later on February 28, 2020. So that's his request. Can he amend the appeal that he filed a couple of months ago to sort of change it so that it now is an appeal of Warner's decision of February 28th? And I thought I'd bring this up before the board. My view of that, so you know it, is the answer is no. This is an appeal of something that Warner did prior to December 27th. That was filed, and now what was objected to at that time is now, in my mind, moot, because Warner changed as,
Decision.
he didn't change necessarily the result of the decision, but he changed the format of the decision and the materials that became a part of the decision. And Attorney Laurie would like to change the appeal filed so that it could now address the decision Warner rendered on February 28th. I just have, again, I'm a procedure guy. I have a real procedural problem with that. It seems to me that you can't appeal something before it happens.
Right.
It's like preemptory. And he's asking if they can convert this vehicle that they have to a current vehicle. And in my mind, the answer is, no, you can't do that. Just withdraw this appeal, and if you feel strongly about the decision, file another appeal.
Right.
That's my view.
Now, is there a cost associated with them reappealing?
Yes,
There is, there's
another application.
there's a fee of some type.
Correct.
And,
They'd have to file another appeal, they'd have to give notice to the abutters, there would have to be a notice published how the town publishes it now pursuant to the newly enacted land use ordinance provision with regard to that.
but they had put in an appeal, but then agreed to waive the 35 days while Warner did some additional.
That's right, because the thought was, I think at the time, that their appeal might be moot if Warner does issue something in conformity with the requirements of a decision under 11.5C.
Yeah, okay.
So, since I got this letter and since we had a meeting, I thought it would be great to throw it out there and see what the board said.
I agree with you. I think that they need to reapply and give us the reasons why they disagree with what Werner's letter said.
Well, I think
which
if they
this-
amended it, they'd give us the reasons too. It's just,
Oh.
can they be allowed to amend to do that instead of filing a new appeal?
And the only difference would be if they file a new one, abutters get notified. If they only amend, would abutters get notified?
I'm not so sure.
Probably not.
It's a good question. I don't know that we have that it's spelled out, process-wise. I suspect what we would do is that we would, in terms of just doing due diligence, and because of the amount of time that's passed, that we would file a new notice.
Okay.
Yeah, it doesn't spell that out, but to me, that just seems to be the correct.
The right thing to do.
Yeah, the correct thing to do. But arguably, we'd go back to the applicant and request additional postage to do so.
I, for one, think that the original appeal was on a certain item, and that item has been addressed, and it's now moot. If they want to have a hearing on that, they can, but I think it's moot now.
'Cause they're
And if they have a
appealing.
new appeal on it, if there's a new decision, then they have problems with it, they should file a timely appeal with regard to that.
My discussion at the time was, I believe that it was a process and not a judgment based on laws and engineering and physics. It was a procedural thing. I know I wasn't in the majority of that, but did we, by saying we agree to extend, leave in their minds, we'll wait to hear from you?
No, well, first of all, the agreement to extend was done by the parties and not by the board, as the ordinance provides.
Right.
But I was circled in on all the communication between the parties, and I did express at the time that the appeal could well be moot if Warner does as he said he was going to do, which he did do. I don't have a problem with the Slager side objecting to Warner's decision and filing an appeal of Warner's decision. They're entitled to do that, that's their right. I just have a problem procedurally with us allowing an old appeal to be retooled to become a new appeal to a matter that happened after the appeal was filed. That's all. And sometimes when I have these thoughts, I know I probably frustrate you guys to some degree, but I'm really thinking of process and procedure and consistency and
Sure.
and form, because I think that those things are, at the end of the day, important. I also think that this is a board that of recent vintage has been scrutinized, and I think it's good for us to be under scrutiny, and I think that it's appropriate for us to be consistent in how we apply our rules and our regulations in the ordinance.
So this, Amy was involved in sitting on this hearing. What's Amy's opinion on this? Amy Chow, town attorney. Does she think we should
I don't think it's
We
been,
didn't-
I don't think it's been,
pass by?
Amy wasn't in on this appeal. The original appeal
second
by
one.
Slager.
Right, the first one, yeah.
That was,
This is the
Amy was
second.
on that, and that decision was rendered.
Yep,
Wayne was chair,
yep.
and the decision was rendered. And my understanding is, I thought with all of the attorneys present and the recordings that were taken, that I thought it was gonna be a decision that was gonna be appealed up to the Superior Court, which is the next step, an ADB. But my understanding, it was not appealed. Is that your understanding?
Correct.
So they didn't appeal that decision. So that was the end of that. That was a final decision, cast in stone for all time. And actually, when a decision is cast in stone for all time, that's one of the reasons why I didn't want to really rescind the prior matter that we had today.
Yeah.
I believe in finality. So, this is not the one that Amy had anything to do with. It's the subject matter, but it wasn't the matter before the board. This is a different matter related to the same subject.
Where it's related to the same subject, will we be asking for Amy's input to sit in on the meetings with us?
Well, we'll wait until we get to that time, but I don't, that's getting ahead of the question.
Yeah,
But I don't feel I have a conflict in this. We'll find out if the parties do.
I'm kind of thinking just to keep dates clean. December was a long time ago, February is now, that was 2019, now we're in 2020. They probably should just make it a new, clean application to come in front of us.
Wayne?
I'm still back to the original part of, it was something, I mean, again, we're not really, since it wasn't on the agenda, specific stuff. But something happened in the office, it didn't get done correctly. It then got fixed.
Purportedly didn't get that
Yes,
correct.
exactly, by what they believe.
Yes.
And that, to me, it almost has a sense that we're overlooking Werner's office, which is Lori's purview, that isn't ours. There's another part too that I wonder, and it's just slightly off subject, is the next party brings in an engineer. And then the next party brings in another engineer later. And then the next party brings, keeps going back and forth and back and forth. So by what you said, by saying, okay, you need to do this now. And then we'll see, then we'll go with our process. And if it happens again, goes too long, or the process isn't completed, and someone else is then brought in, okay, I think each time it should be made clear to them and to everyone that we'll start from fresh unless we extend it, and that's the part I think just needs to be careful of, that's all. I think this is going to continue. So by what you're saying is it's time to start, bring us another one.
Yeah, I'm saying that,
And then when it happens again, bring us another one.
well, I just think that the appeal that was filed I think that Attorney Laurie agrees with me when he says, I agree that the pending appeal does not lend itself to addressing the merits of the CEO's amended decision. He agrees with me that the appeal that they filed does not address the actions that Warner just took. So if he agrees with me then he can either have his hearing on the older item, which I don't think he wants to have because it's not the issue he's really interested in. He's more interested in the substance of the decision that Warner rendered on the 28th. And I think that that's a different appeal than that what was filed before. I think you can amend appeals in that, like, the party that did the appeal before was a different entity that morphed into another entity. That's one thing. But everything else was identical, the substance, the sum, everything was identical, and the timeline was the same as well.
Is he wanting to amend to save time, to save paperwork, to not do another abutter filing?
He didn't articulate that, he just wants to know if he can do it.
Okay.
If this board allows for such things. I would say no.
I would say no.
I say no.
I say no.
I say no.
Look at that, we say no.
You're a no way.
Yeah, it's,
We need
as I
fresh
said,
paperwork.
it's,
It's a different
every time
bag.
you do it, we'll start over.
Yep.
Yeah.
All right, then I'll have to get an email out to him tomorrow. I'll loop you in. And if you don't see that, would you please, tomorrow's my last day before vacation and I'm stranded.
Hope you're not going on a cruise.
No, but I am going
Oh,
to
so
Florida.
Ken, did we talk about, getting the findings to them?
Did
I
we-
can type them tonight.
Time-wise, well,
Time.
I'd like to, all right, so we're done with Lowry?
Yep.
All right, with regard to the decision, I'm stretched tomorrow. I'd like to take a quick vote to allow the vice chair to sign the decision of what we heard, and the matter we heard earlier today. Can I hear a second?
I'll type them, you proof them, and then Wayne will sign
If I can
the
get to it,
final.
I'm just afraid I'm not going to because of my timeline.
Okay, yep,
Yep.
okay.
Second,
Second,
all in favor?
third, fourth, favor.
Wayne signing. I guess I could have asked you first, but,
I didn't raise my hand.
oh, well.
Do we do motion?
Then let's hear a motion.
Motion to adjourn?
Second.
All in favor?